on it right now. Yeah, nobody's here. I just talked to the lady and she told and signed John in. So far, I'm doing okay. 9:30. Oh, that was the last one. That's an old one. Look at the date on that. It said 7/18. Yeah. Yeah. So this. I talked to the clerk, whatever. She asked me his name. I said, "This is his wife. I'm here for John Murphy." Okay. 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 You know what? I don't. If you're on your phone, that's why I couldn't answer you here because it rang. And I said, "It's fine." Yeah. Okay, honey. All right. I'll talk to you after it's over. Okay. Bye bye. He's going into the meeting.
Yeah, like I said in the car, it's $2,500.
Morning, sir, who just signed on. What is your name, please?
My name is Leora Cameron.
No, thank you, ma'am. Sir, with the cap on and the glasses, can you hear me?
Yes,
Hi, what is your name, please?
Thomas Rousseau, Rousseau.
What case are you here for?
I'm John Murphy. He's my stepfather.
Oh, are you an observer?
No, I'm here to speak for him because he's got some issues with dementia and things.
Could you spell your last name again, please?
Rousseau.
Thank you.
Good morning. Today is Tuesday, September 5th, 2023. This is courtroom number 1. I am Judge Martin. Today's docket is exclusively civil cases, landlord-tenant cases. If you don't have that type of case, you are likely in the wrong courtroom. You may send a message to Mary Ann. She'll help you get where you are supposed to be. Do you want to grab the chair of the witness, or you just want to stand here? Okay.
I'm gonna go jump on because Mary Ann can't get on her face, so I'm gonna start.
Ma'am, you're not smoking in court, are you? I can't believe that you are.
Okay, so grab a chair and-
And before we even begin, I will ask that everyone be patient with us today. We are using the My File system in the courtroom for the first time. So it's going to take us just a moment to make sure that people are checked in and connected to who they're supposed to be connected to. But we are actively working on it. You're fine. You want to come up so you can see? No, you're fine. You're fine. Mr. Barta, have you spoken to Mr. Murphy?
Good morning, Judge Martin. I have not spoken to Mr. Murphy.
Okay, let's get you into a breakout room with him so you may discuss your case. Mr. Murphy, you should see an invitation to go into a breakout room with Mr. Barta. Please go in there, talk to him about your case. Once you've had an opportunity to talk, you may come back to this main session. I'll get your case called.
Actually, Your Honor, I completely apologize. I believe I looked at Mr. Murphy's answer, which stated he's filing bankruptcy, and he actually has a bankruptcy attorney's name and number. So I don't believe we don't need to speak at this point.
Mr. Murphy, do you agree with that assessment? I need you to unmute yourself, please, sir. Mr. Murphy, is there someone there with you, or do you understand how to unmute yourself? I can't hear you. Mr. Murphy? Mr. Barta, I'm not sure what happened to him. He's in a breakout room. Let's get him back into this main session.
I'm bringing him up, Judge.
Thank you. So I think ideally, when she checks them in and marks them ready for hearing, they'll come up into this. And they should pop up here as ready, but since no one's ready.
Mary Ann, could you maybe chat me the people that are here for what cases
Yes.
so far? Thank you.
Mr. Murphy, okay, let's get him unmuted so we can get this case called.
Say, yes, Your Honor.
Yes, Your Honor.
Thank you. This is 232641 GC LVMV Funding versus John Murphy. May I have your appearances, please?
Good morning, Your Honor. Suzanne Barta, P65425 on behalf of the plaintiff.
Mr. Murphy, state your name for me.
John Barlow Murphy.
Thank you. Typically, Mr. Murphy, the parties go into a breakout room and speak, but there is an answer that you filed that indicated that you'd be filing bankruptcy. You listed the name of the attorney. Have you filed that bankruptcy yet?
We're going to this week.
We're going to this week, I believe.
Mr. Barta,
Your Honor, I would ask for maybe adjourning this matter 30 days in hopes that that bankruptcy is filed, which will, will stay the proceedings.
thank you. Mr. Murphy, the court will adjourn this matter unless you have an objection. We'll adjourn this matter over to October 3rd, 2023 at 9:30 a.m. We will be back here on Zoom, sir. Court staff will mail notice of that new date and time to you at the address that you verified with staff previously and that address that appears on your answer. If you have not completed your bankruptcy filing, we'll have the pretrial. So, sir, as soon as you get that file, your bankruptcy attorney will know what to file with the court to stay or stop these proceedings. Understood?
Yes, ma'am.
Anything else, Mr. Barta?
Not at this time, Your Honor.
Thank you. That concludes this matter. Mr. Murphy, you're free to go. I will see you on October 3rd at 9:30 a.m., sir. Have a good day.
Thank you, Your Honor.
You're welcome, sir. Mr. Ivanchek, have you had contact or communication from the defendant's attorneys?
No, Your Honor, but we settled this with Judge Green. We're just waiting on a settlement agreement. I emailed counsel that was supposed to draft it last week. I didn't hear back from
That's a problem.
him. Which part?
Well, I saw the note regarding the mediation with Judge Green, when attorneys are slow to get paperwork filed, it always makes me concerned. But that being the case, what we'll do on 230903 GC, Genesis Johnson and James Cheatham versus Robert Funk and Danielle Egger. Were you expecting the other attorneys this morning, sir?
I've not heard from anybody, Your Honor. And like I said, I emailed everybody involved on Thursday asking about the settlement agreement. And obviously my clients aren't here either. So maybe we all got our signals crossed here.
Well, what I'll do, Mr. Ivanchek, is adjourn this matter over till October 3rd, 2023. I'll have Civil Department noted as a final pretrial. And hopefully between now and then, that's sufficient time for you to be in contact and communication with the other attorneys to get that paperwork done.
Yeah, I'm emailing them right now. Did you say 9:23 at 9?
10-3 at 9:30.
All right, well, I was way off.
You're just making up dates, sir, but that's fine with me.
Yes, 10:03 at 9.
But if you all are able to get that executed, just submit it through my file. We'll get it signed and back out.
Okay, thank you, Your Honor.
Anything else?
Nope,
Have a good day.
thanks, you too.
Thank you. This is 232450 SC. This is Leora Cannon versus Courtney Moore. Please unmute yourselves and state your names for the record.
Good morning, Your Honor. This is Leora Cannon.
I'm sorry, did you state your name, ma'am?
Good morning, Your Honor. This is Leora Cannon.
Thank you, Ms. Cannon.
You're welcome.
Ma'am, today was the day and time set for hearing on the defendant's motion to set aside the default judgment. This was scheduled at 9 o'clock. It's now 9:11 by this court's clock. My policy is about 15 minutes after the scheduled start time. But in as much as this is the defendant's motion and he's not appeared, and he failed to appear for the trial that we had back on July the 18th, unless there's something you want to say in response to that motion, ma'am?
No, I'm asking you to dismiss his motion and to keep the default judgment in place and close this up.
Ms. Cannon, the court will note that the defendant has failed to appear for hearing on his own motion. That motion will be denied in its entirety. If you have not already started to do so, ma'am, you are free to begin your post-judgment collection efforts.
Okay, just one question. Do I have to wait from today or from the original judgment date?
Original judgment date.
Okay, thank you very much, Your Honor.
Anything else, Ms. Cannon?
That's all. Have a great day.
Have a good day, ma'am.
Thanks, bye.
Mr. Barta, if Mr. Desmute is not here by about 9:30, I'll call the case. So if there's something else you want to go do in the interim, unless you just want to hang out to see if he appears.
I will remain, Your Honor. I actually have 6 hearings starting at 9:30 in the 36th District Court, so I hope he appears shortly.
Understood. Thank you.
Thank you.
Ms. Lambert,
Yes.
we have not seen Mr. Lazar just yet, but the case was scheduled at 9:15. My policy is about 15 minutes after the scheduled start time. So if he's not here by about 9:30, I'll get, or some representative from his office, I'll get your case called, okay?
Thank you.
You're welcome. So I came in this morning, I had to download OneBase in here again, because I've been using it in my office. So I logged on, I have reviewed it last week. And in theory, what Sandy says is that Marianne will go in and check in people here, indicate who's here for the parties, and then ready for hearing, yes, and it'll move it into here, which it just did. So Sandy must be doing her magic stuff.
So those are the 3 from that you just did, Judge, and you can wait to put notes on them later on, but that's just so you'll have the file if you need it.
Well, there's no match right now, Sandy. So
Right.
I'm looking at Murphy.
Okay.
So if we go in there and mark it as held, and we'll get
But you have
the
to put
attorney for
notes on it
Pioneer.
first.
I have to put notes on it where?
Okay, so if you double click on it, I'm doing Funk. I'm not going to do Murphy because I can't. So I'm doing Funk.
If I double click on,
Oh, go to your related items. I'm sorry, it's going to take me a minute to find this again.
is it in
Sorry.
the hearings jacket?
In the bench.
I'm in the bench.
Yep, and you're on Murphy, correct?
Yes.
Okay. There is, I'm trying to find it again. I had it with Judge Oakley and now I can't find it.
Mr. Lazar, Ms. Lambert is here. We'll get you into a breakout room with her to discuss the matter.
Thank you, Your Honor.
You're welcome. Ms. Lambert, please go into the breakout room with the attorney from Pioneer.
Can I check in? I'm just.
Okay, how do I do that? I'm sorry.
Nope, she's doing it. This is all I'm doing.
Oh.
Ma'am, you should see something on your screen that invites you to go into breakout room number 2. Okay. Sandy? Mm-mm. Good morning, Ms. Webster.
Good morning.
What are you here for, ma'am?
Mary Jones. I represent Mary Jones.
Thank you. I have not seen anyone from Ms. Dillow's office as of yet.
No.
Case isn't scheduled until 9:30.
Yeah, but said sign in 15 minutes early, which I normally do anyway.
I appreciate that. Thank you.
No problem.
Sandy?
Good morning, Judge. This is Mariah. Sorry, Sandy's on her way in.
She just came in the back door.
Oh, wonderful.
So what are we looking for? Okay, so we're in the hearing for Murphy, which we did, but you said don't do anything. You said go somewhere else first.
Is this the one you're doing right now?
No.
Okay. Yeah, I'll get you there later.
If you want to move, do you have anybody here yet? Or no? Another case ready? No?
Well, wait,
Okay, help me out here.
oh,
Get off
why is
that,
this?
yep.
Yeah, I was like, why is this?
No.
No, okay.
Just that little X. Nope. Oh, yeah. Nope. The little X. Okay, that's good.
Yeah.
Okay, so this is your bench. So if you click on one of these cases.
Does it matter which
No.
one? Okay.
Okay, so from here, there's a place where you can do your notes. I'm not sure where. Can you double click on this?
You said related
Let's
items?
try that. And then scroll down.
Down?
Yep, you scroll. Because that's where I thought it was right here. Go to documents for hearing. Filings not reviewed. Hearing jacket. Double click on this one. I have to figure out where this is. When I figure that out, I will come back.
It's
I
fine.
had it Thursday when I left and I just didn't write it down. So, but there's a place where you can put notes and then we're just gonna have you write in what happened so that we can see it.
Okay, it's fine.
User interaction. It's inbox, I'm pretty sure.
It's inbox.
I'm pretty sure.
Case notes?
Just keep going down, right there. Enter the note here.
Thank you.
So whatever happened.
Okay, that was fun, thank you. Oh, of course I have it. Adjourn to 10:03 at. Okay,
And then save.
save.
And then you can go ahead and hearing complete.
Oh, at the top, okay.
And then that one, send that one over there.
Oh, that was 9 kinds of fun, thank you.
So yeah, so view case notes, that's the easy one. Remember that? At the top, so you can do
Okay.
this one too if you want.
That was interesting, okay. I
Just
have,
have to scroll all the way down.
that's fine, okay, so this was Johnson and Funk.
Yep, there's your case number or
okay.
Yep, so it's pretty easy, but you might not be able to do it while you're doing everything. I don't know how good you are.
What'll happen is I'll have times
wouldn't
like,
be able to
I'll
do
have
it.
times like this,
Yeah, and then you can.
and I'll do it then.
Am I on that one?
No, Judge Oakley is, which I don't know how Judge Oakley could be in our hearing docket.
Yeah, I don't know.
Hearing's complete. There's one more ready for the bench. Mr. Lazar, were you ready with Miss Lambert?
Yeah, we're ready, Your Honor.
Okay, she's not out of the breakout room. Give us a moment to get her moved out.
Okay.
I'm trying, Judge.
See?
I'm gonna go in
Oh, I
there.
have it. Thank you, Mary Ann. They can't even see you. See, because I have it.
So Mariah should be checking these people in and then she should be sending that to the bench.
Okay.
The next one.
Okay.
So you'll have the file there, so you can just click on it and you can go to related items and then you should see it.
Why am I the guinea pig for this? It's fine. It will be fine. It's fine. Trust me. It just takes, it takes something to be used to not having paper. And when I was doing the review, I was using the filter function to find where I wanted to be.
Okay.
So it worked out nicely.
Yeah. And that's just it. You have to know how to get to anything to do everything. And that's the problem. We haven't done it enough to do that yet. Give us a month or two.
Mr. Lazar,
I should.
sir,
Yes,
Miss Lambert wishes to speak with you again.
okay,
If you can join her in the breakout room.
sure.
That wasn't my imagination, right? That's just a little profanity for 9 o'clock in the morning. That's nice. Okay.
So that's that. So, yeah, and that's what I was wondering, how you would be able to move through it. But as long as you have them coming to the bench in time, like when they're checking in, and then we'll send the file right, then whoever it is will send the file right to your bench. That's what I was worried about, you not having the file.
Well, what should happen then is
Mr. Lazar?
Yes,
Okay.
people should be checked in, moved into the breakout room, and while they're moved into the breakout room, the file should be marked as ready, so that when they come back out, the file's already here.
Yes.
Okay.
So it should be sent to the bench while they're in the breakout room.
Okay.
But we don't know, because Mary Ann started checking in people before I got on. I don't know who she's got in there. I didn't go to the breakout rooms to check.
It's fine.
to
No,
see.
the only person, we're on the 915 cases, and the only one that's showing on the bench is this last 9 o'clock case. I just need to put notes in.
Yep.
But here are my 915 people. This is 230281 GC, credit acceptance. Nope. 233084 GC, Pioneer Financial versus Marquetta Lambert. May I have your appearances, please?
good morning, Your Honor.
I'm Marquita Lambert.
Good morning, Your Honor. Jay Lazar on behalf of the plaintiff, P69480.
Thank you. Today is a day and time set for the pretrial in this matter. The parties have had the opportunity to speak. Mr. Lazar, how are we proceeding this morning?
Your Honor, my understanding, and I'll let Ms. Lambert speak for herself, obviously, is that she wants to send us something to show that the balance should be otherwise than what's in the contract that was filed with the summons and complaint. She is interested in a payment plan, but at this time, she wants the opportunity to send us whatever it is she would like us to look at that would somehow contradict. Again, we have the full documentation, signed contract, affidavit, statement of account that was filed with the summons and complaint. But I said we would absolutely ask for another date and give her the opportunity to mail us whatever it is she would like to send us.
Ms. Lambert, is that an accurate statement of your conversation with Mr. Lazar?
So I don't know how to say it technically, but this is my same answer to the complaint. It's from the beginning, when they changed my payment, I was inquiring why was the payment changed. I didn't purchase anything additional. My account was for approval was for $1,000. I purchased things within the $1,000. I was making payments, and then all of a sudden everything changed. And I was still paying, but then it was like it was no incentive for them to get me the information as to why was the payment changing, or why was the cost or whatever changing. And I have never, and I went back and forth to the store until the store closed to get, I'm sorry, go ahead.
Ms. Lambert, my question to you is, Mr. Lazar indicated that there was something you wanted to send to his office to dispute the balance. And my question to you was, is that an accurate statement of your conversation with him?
Right, I need to find out. I don't know how to get all of the documentation that's needed.
Okay, Ms. Lambert, the court did review your answer. And in your answer, you talk about a credit limit being different than what's being sued for right now.
Right.
So do you have some documentation that you want to send to Pioneer to show that the balance is different than what's listed in the complaint?
I don't have it in my hand. I need to find it.
Okay, you need to find it like it's in your house, or you need to find it like it's somewhere else?
Well, I need to try to reach out to the company to get the information.
So you don't have documents to send to Mr. Lazar?
I don't have anything in my hand, no.
You don't have anything in your possession, period, correct?
Not that I know of. The reason why I'm saying this, I'm gonna say this clearly. We moved from the house that we are, so I have to go through boxes to see if I can find it, or I have to reach out to the Tidewater to see if I can get the documentation.
Then, Ms. Lambert, what I will say is that between now and October 3rd, you should send Mr. Lazar's office as the representative for Pioneer Financial, whatever documents it is that you want them to consider. We will come back here on that date, October 3rd at 9:30 a.m. to have another pretrial. We'll adjourn today's pretrial. The parties will exchange whatever documents they deem necessary to be able to have a meaningful conversation at that adjourned pretrial date. Is that reasonable, Mr. Lazar?
Yes, Your Honor, that's perfect. I appreciate it.
Thank you. Ms. Lambert, the court staff will mail you notice of that new date, October 3rd, 2023. In the interim, if there's something you want to send to that plaintiff's attorney's office, do that. When we
Yes,
come back
ma'am.
on the 3rd, the court will be looking to move this matter forward and get it scheduled for trial if you're unable to resolve it with Pioneer, okay?
Yes, ma'am.
Anything else, Mr. Lazar?
Yes, Your Honor, do you, can we use that date as a motion date, or do we want to wait till October 3rd and then assign a motion date at that time?
It's your case. Do you want to use it as a motion date?
I don't mind doing another pre-trial. I just want to make sure that, Your Honor, there's enough time on your calendar as well to, at that point, assign a motion date.
Mr. Lazar, this courtroom does civil cases on the first Tuesday of the month. So if we're back here on October 3rd and don't have a resolution, we'll move it on to November 7th. If we need to set a motion date in between, we can talk about it on the 3rd, okay?
Perfect. I'm more than happy to give her some time to get us whatever she would like first and see if we can resolve it that way.
Thank you. Anything else, Ms. Lambert?
No, I appreciate you. Thank you very much.
No worries. That concludes this matter. You have a wonderful day. I'll see you on October 3rd.
Thank you, Your Honor. Have a great day. Good to see you.
You too. This is 230291 GC Credit Acceptance versus Desmute.
Good morning, Your Honor. Cezanne Barta, P65425 on behalf of the plaintiff.
Thank you, Mr. Barta. Today is the day and time set for hearing on the defendant's motion for installment payments and the plaintiff's objections. The court did review both the petition for installment payments and the plaintiff's response. Case was scheduled at 9:15. It's now 9:30 by the court's clock. The defendant has failed to appear for hearing on their own motion. Mr. Barta, how would you like to proceed?
I would respectfully request that their motion be denied at this time.
Thank you, sir. Based on Mr. Desmute's failure to appear this morning, the petition for installment payments will be denied in its entirety. The garnishment that is in effect shall continue. Anything else, Mr. Barta?
No, ma'am. It was great seeing you.
Good to see you, sir. Have a great day.
Thank you.
Thank you. This hasn't been so bad, has it? No. I'm glad it's not a busy day. Yes.
Quick refresh. Go to your.
Why are you breaking our nice stuff?
I think you can just fill it out.
Just a regular F5 or?
It should be right there, refresh.
Oh.
I didn't see it either. Yeah, so see, it's there. It just didn't come up, so you might have to click that every once in a while.
Okay.
To get the cases come up. 'Cause I went down.
Why don't you just call?
I'm like, I said, can you send that up? She goes, it is. I'm like, no, it's not. So, yeah.
Okay, but then while you're up here, that's the thing, the spelling part of it.
And I don't. Yes, I would put docs because I don't.
Well, if we were in a rush, maybe. Okay, but then this is what happened. I don't know why.
Just click OK and see what happens. Does it come back up?
So I don't know if you're maybe in it.
But it wouldn't be, it would say my name.
Oh, but is he in his office? Does he have a docket today?
Does he?
I don't know.
Yeah, I don't know. I can go check and make sure that he's.
I can't imagine why he would be in there by mistake. But we'll, you know what? Don't check.
We'll wait. till-
We're not gonna worry about it.
Yeah. Yeah.
There's a glitch in the matrix.
Can you,
So
where's your phone? I'll go call Mariah and ask her if she, no, because my phone's on do not disturb. That's why. I
what's
can't call.
Mariah's number?
She's in my office and
Oh.
my phone's on do not disturb.
It's fine. Oh, Mariah's right here. We can ask
Yeah,
her.
there you go.
I am right here, Judge. How can I help this morning?
Ma'am, we have one file in the hearing, in the bench queue that says that it's locked because it's in use by Judge Oakley. You cannot
Okay.
view document. And I wasn't sure if it was still up on Sandy's screen or if there was something else.
It is. No, I will contact Judge Oakley's office and ask him to get off of that document.
Huh,
That's weird.
it is weird.
And like Malachi said, it said that he was on it, but it was actually me on it at one time, so.
And we're lucky because right now we are in the 9:30 part of our docket. We haven't reached the time for the 9:30 failures to appear, so we can get the notes put in, figure out what's going on. And
And that's what I thought because it wasn't a heavy docket.
it's not, thank goodness.
That's what's going to be in there.
Okay. See, so do you go back in and fix that date? Malachi does. So if I sign it, you'll go back in and fix that date. Okay. Which it took me a
You
minute to.
don't have to identify the judge. You are being very generous because your signature has the date.
Oh,
So, yes. So, yeah, so.
well, so
And, can you sign this one with the seal? Because we're trying something new, so if you just, yep. Yeah. Because they're telling us that this should write to JIS with today's date. So we're hoping that works.
So,
This is gonna be the
what are you
test
saying?
document. That's what they're saying it's supposed to.
so we should take this off?
Yeah.
Okay. Oh, how do you
Oh, there to delete note.
delete? No, thank you. Okay, yes, yes. And then we go back here and send it there. And it's, I think it's coming along.
Yeah, you guys are doing great with this part of it. Everybody's doing great with that. It's just this part now. We're gonna
It's
have a few
fine. We'll
hiccups
we'll
and
just, we're easing
that's why
into
I'm
it.
glad so sorry, but yeah.
It's fine. No, and there's no, yeah, I keep checking. There's nobody in the breakouts. It's 9:38, and I'll call these next two at 9:45. And so at what point do you mark them downstairs as having failed to appear?
That's gonna be the thing.
Okay.
Because Mary Ann would be doing this normally, and she would know that at 9:15, right? That you wouldn't.
My policy is about
Yeah.
15 minutes after,
So-
because I allow for a little time for technical glitch.
Yeah. So
Okay.
When you say, like I was doing, I was listening to you and you said the defendant failed to appear. So then I just sent it right in.
Oh,
I
okay.
was listening to you and I just sent it right to the bench at that point. So it's just gonna take a little getting used to when you want it or.
Because I assume if you're not a regular Zoom user, that you might have some connectivity problems. You might not have downloaded, or if you used it before, you might not have updated.
Right.
So the 15 minutes allows you time to work out your kink and get you.
Right, because you should be actually getting on earlier.
I know, like Ms. Webster was on early. She read her notice. I'm a big fan of that. Because I do that when I have Zoom, even though I keep mine updated, my personal one updated, I still log on early because things happen.
Yes.
Who are you hiding from? Look at it. Why are you breaking our nice stuff?
Do I still have you locked out?
Yes.
I don't know how to get out. I just closed the on base.
Okay.
Yep. So that's good.
Nope. Whatever, it works now. Whatever you do. Thank you. How many people does it take to do a single on-base case? The answer is 6. Okay. Cannon and Moore. Okay. And that's why when I'm in it, what I try to do is be,
Somewhere you're not, that's not.
I try to get out.
Yeah.
I like close all my things and get out.
Yeah, that's the, a glitch, but it's also a good thing too, I guess.
It is, but so everything is in. All the notes are already made. We still have a little bit of time for the 9:30s.
Yep. So all you're waiting for is
People.
and the bench, the aisles to come to the bench. Yeah.
So now you see what it looks like. We know where to put the
Yes.
notes in.
Yeah, that's the best part.
The abbreviations will get better over time.
Just for you, if you don't mind typing, that's, I hate typing. So, but yeah, so I think we're all good. I'm good.
I'm good.
Okay, awesome. I'll let Malachi put the chair back for us because it's a very heavy chair.
Well, I forgot that it's that chair because it was one of the purple fabric chairs. You're fine. Okay.
Yeah, I'm trying to train you so that I can answer all your questions. That's why.
Oh, that's why.
Thank you.
No, you're fine. I thought you had the witness chair. I didn't realize you had a jury chair. They're slightly different chairs. I think the witness chair is a little. Well, thank you for your help this morning. I'll see you later.
Judge, while we have a moment, if I could interrupt.
Absolutely.
Thank you. I saw Attorney Barta here earlier. We have him checked off on case 232641. Defendant's last name of Murphy.
Yes, ma'am.
And he was here on behalf of credit acceptance. Is that correct? Or I'm sorry, for Attorney Olsey?
Correct.
Okay. Was he also managing the case 230281, defendant last name of Dismuke?
Yes, ma'am.
Okay. I did not send that file through to the bench, so I will do that.
Thank you so much.
Thank you, Judge.
This is 233235 GC Citizens Bank versus Mary Jones. May I have your appearance, please, ma'am?
Stella Webster, attorney for Mary Jones.
Ms. Webster, my apologies. This is the day and time scheduled for the pretrial, scheduled at 9:30. It's now 9:44 by the court's clock. There is no response to the call for Citizens Bank. Have you had contact or communication with plaintiff's office?
I have.
Any resolution of this matter?
No. It's a little dicey, so.
Based on their failure to appear this morning, how would you like to proceed?
I'd love for it to be dismissed.
Case having been scheduled at 9:30, it now being 9:45 by this court's clock. The defense motion to dismiss is granted. That dismissal will be without prejudice. Anything else this morning, Ms. Webster?
No, Your Honor, thank you.
Thank you. That concludes this matter. You have a wonderful day.
Thank you, you too.
Thank you. This is 231885 GC. This is LVNV funding versus Cynthia Corrala.
Here, Your Honor.
State your name for me, ma'am.
Cynthia Carola.
Ma'am, the last time we were here, it was court's understanding that the parties had reached a settlement of this matter. Is that correct?
Yes, actually, on the first hearing on the 18th of July, I made my down payment of the 3,500, and they were supposed to have the documentation to the court. And then last week I called them to inquire about it, and they said they were going to put a paralegal on it, but I don't know if they ever sent everything to you or not.
Ma'am, the court has not received a signed conditional dismissal, which is the conversation that was had both at the July 18th hearing and the August 1st hearing. Have you signed or reviewed, electronically reviewed a settlement document for this case?
No, I haven't seen that either, and I've been paying on it. It's just crazy.
Ma'am, the case was scheduled at 9:30. It's now 9:47 by this court's clock. Plaintiff's office has failed to appear. How would you like to proceed?
What do you mean? I don't
Well, ma'am,
understand.
I understand. The case was scheduled. The plaintiff has failed to appear. Based on their failure to appear, the court will dismiss this matter. That dismissal will be without prejudice. They are free to raise the issue again. If you have some other agreement with them and you wish to continue to make payments, that is your absolute right. But they have failed to appear. They have failed to present a signed settlement agreement in this case. The court will deem the matter concluded for this morning.
So, okay, so I made my 3,500 deposit and I've made 2 monthly payments of 110. So you're saying that this is dismissed and I don't owe them any money? Or?
No, ma'am, that's not what I'm saying at all. What I'm saying is that the case has been adjourned twice for the parties to sign and file with the court a settlement document. That has not been done. I would suggest
Okay.
that you follow up with them, with plaintiff's office. I'm not sure why it's not been filed. I cannot guess.
Okay, so am I supposed to be, keep coming back every month until they do this paperwork?
No, ma'am. The court's not
No?
rescheduling this matter.
Okay, okay. So I would just have to call them to get the paper, because I haven't seen anything or signed anything. But I have been making the payment.
I understand. So what I'm suggesting is that if you are going to continue to make payments, just keep proof of your payments. There's no
Okay.
explanation for there not being a settlement document. The court is not rescheduling the matter.
Okay,
I'll consider the matter closed at this point.
okay, sounds good.
Okay, anything else this
Okay.
morning, ma'am?
Nope, that would be it.
Have a good day.
Too. Thank you.
Thank you. Good morning, Mr. Morton.
Morning, Your Honor. Hope you had a nice holiday weekend.
I did. What about you?
Yes, we just, although we spent about 2 hours just juggling childcare, but other than that, it was fun.
I have not seen your other side as of yet, but it's still early.
Understood. I don't anticipate that they intend to appear. I know this was one that we re-noticed up after, for some reason, we didn't get the original notice, but those things happen. But we believe that the unit likely is empty, but we want to make sure that we take all the necessary steps.
Understood. I'll call the case at about 10 o'clock.
Thank you very much.
You're very welcome.
This is 231771 GC Reliable Auto versus Michael McIntyre. May I have your appearances, please?
Good morning, Your Honor. Jeremy Chisholm, it's P74670. I'm the attorney of record for the plaintiff.
State your name for me, please, sir.
Michael McIntyre.
Thank you. Today is the day and time set for the adjourned pretrial in this matter. The last time that we were here, there was an indication that there was a consent judgment forthcoming. Mr. Chisholm, how are we proceeding this morning?
Judge, that is still the plan here, Your Honor. What happened, Judge, in my best guess is that the proposed consent judgment was filtered out by by Reliable's firewall, and Mr. McIntyre didn't receive it. We have amended the terms a little bit to account for the fact that he didn't get it. And I believe the paralegal at Reliable who has the DocuSign account always copies me on this as well, and I didn't get it either. And I think this is a technical glitch, Judge, and so I would like a chance to submit this again. And like I said, we have an arrangement in place. We've got a deal together. And Mr. McIntyre, if he doesn't get it by the end of business tomorrow, he's going to contact me, and I'm going to go ahead and mail it to him if that's the case. I tried to do this DocuSign thing thinking that it was the safer, easier, more reliable way of getting this thing taken care of. But if that firewall is preventing the transmission of something that either looks like a birthday or a social security number to it, and there may be something on there that the series of digits is being filtered out. And I think that's what's happened. It's happened a couple of other times recently.
Sir, is that an accurate statement of your conversation with Mr. Chisholm?
Yes.
Then what the court will do, sir, is adjourn this matter over to October the 3rd at 9:45 a.m. back on Zoom. Court staff will mail notice to the parties of that new date and time. And in the interim, Mr. Chisholm's office will resend the consent judgment. Once it's signed and filed with the court, that October 3rd date can be taken off of the calendar, but we'll leave it there as a placeholder because this is now the second time that the matters had to be adjourned for the consent judgment to be filed. Mr. Chisholm, anything else this morning?
No, Your Honor, that's all for us. Thank you, Judge.
Thank you. Mr. McIntyre, for anything else, sir?
No, that's it.
That concludes this matter, sir. You're free to go. You have a wonderful day.
You too. Thank you.
Thank you, Your
Thank
Honor.
you. This is 231321 LT. This is Harbor Club versus Fields and Fields. May I have your appearance, please?
For the record, Your Honor, Attorney Ian Morton of Pallets Law on behalf of the plaintiff.
Thank you, Mr. Morton. Today is the day and time scheduled for the plaintiff's motion for an order of eviction. The case was scheduled at 9:45. It's now 9:59 by the court's clock. There's no one responding on behalf of the defendants to the case call. How would you like to proceed this morning?
Your Honor, at this time, we would ask that the order of eviction be entered. This was originally a conditional dismissal, before the court? But since that point, no payments had been made on the account whatsoever, which was provided for and attested to in the affidavit of noncompliance. At this time, as well, Your Honor, the past due balance is $8,114.13. I spoke to my client this morning. They confirmed that they have not received any payments as well. Also, they've confirmed for me that they have not received possession, having been turned back over to them. So based on the fact that the tenants have failed to abide by the original conditional dismissal, which was entered back in, it was either the end of May or beginning of June, for about a $4,000 plus payment, which has not been made. We would ask that the order, actually was a judgment be entered, and then subsequent order of eviction be entered as well.
Thank you. Defendants having failed to appear as directed by this court, plaintiff's motion shall be granted, default judgment shall enter, and an order of eviction shall issue. Anything else this morning, Mr. Morton?
The only thing I would ask, Your Honor, is based on the wonderful new e-filing system, would the court like me to submit those after the court hearing?
Would you please, sir?
Absolutely, Your Honor. We'll get those submitted today then. Thank you very much.
Thank you. Have a good day, Mr. Morton.
You too.
Thank you. Good morning, Mr. Katz.
Good morning, Your Honor. How are you?
I am wonderful, sir. How are you?
I'm good.
Would you like to speak to Ms. Miller, or are you prepared for the case to be
No,
called?
let me speak with Ms. Miller.
We'll get you
Thank you.
into a breakout room.
Yep.
This is 233169 LT Maxwell versus Miller. Unmute yourself, turn your videos on, and state your names for the record.
Good morning, Your Honor. Sydney Katz on behalf of the plaintiff.
Samantha Miller.
Thank you. Today was a day and time set for the hearing on this adjourned non-payment of rent landlord-tenant matter. Mr. Katz, how are we proceeding this morning?
Your Honor, I did speak with Ms. Miller. She says that there's still one other issue that still needs to be addressed by my client. With the holiday weekend, my client was not able to get back to me until just now. I talked to Ms. Miller about adjourning this one further time, making sure that everything has been resolved. There is a pretty significant balance of $5,409. However, there might be some adjustments. I'm not sure, but I do want them to meet in person and give my client access to make sure that everything that needs to be addressed has been addressed, Your Honor.
Ms. Miller, was that an accurate statement of your conversation with Mr. Katz?
Yes.
What is the outstanding issue?
I have a outlet that hasn't been fixed. That could be a fire hazard, and then my bathroom had a bubble in the ceiling.
Mr. Katz, how long of an adjournment do you think is necessary?
Maybe 2 weeks at the most, if possible.
Ms. Miller, is that sufficient time for you? 2 weeks?
Yes.
Let's look at a date. Mr. Katz, are you available on Tuesday, the 19th of September?
It sounds good.
Ms. Miller, are you available on that date?
Yes.
Ms. Miller, do you have a time preference on the 19th?
Morning works fine.
This courtroom is scheduled for arraignments that day, and there's something else, looks like 9 o'clock. So we say, let's say 9:30 on September 19th.
Sounds good.
Anything else, Mr. Katz?
No, I'm just hoping I'm not one of your arraignments.
Anything else, Ms. Miller?
Nope, that's it.
Court staff will mail notice of that new date and time. Otherwise, you're free to go. Have a wonderful day, Ms. Miller.
Thank you, Your Honor.
Thank you, you too.
You're welcome. Take care. The next case is not scheduled until 11 o'clock. This court will stand in recess.
Hello? Hey, Mr. Barry, how you doing?
Fine, I don't know if we're in
I mean, we gotta be quiet. Yeah.
Cellular data, versus audio. Okay, that. The volume is up. Trying to see courthouse to the right. Up is the right.
To the 11 o'clock parties, I'll be out to call the case shortly.
Your Honor. Now we're looking for a PNC. There's the courthouse. There's a PNC right here. Make a right, and it should be parked in the back. There it is. Pull it in front. All right, let's go in. Yeah. So, you know, you try to make sure your hair is posted as early as possible. Yeah. What I do is also be as far as it possibly can be. Get your hair Yes, yes, please, because I'm in court right now. I'm in court. Look, I'm in court. I'm in court. So let me call you back in a minute. I'm in court. All right, thank you. This is just right. Hi. I called. I'm the lady with the fraud problem.
Ma'am,
Yes.
I don't know if you're aware of this fact, but you are not muted. This court is actively in session. Every
Excuse me.
conversation you're having is being transmitted. This is 232958LT. This is Ashaka Investment versus Jacob Moore. May I have your appearances, please?
Good morning, Your Honor. Barry Brickner on behalf of Ashaka Investments. My client is also here. Aha, you want to unmute?
Mr. Moore, state your name for the record.
Yes, Jacob Moore.
Thank you. Today is the day and time set for hearing on the non-payment of rent for the storage listed in the complaint. Mr. Brickner, are you ready to proceed this morning?
Yes, Your Honor. This is the 5th hearing on the matter. It was adjourned so they could get an attorney. I haven't been contacted by anybody.
Mr. Moore, are you ready to proceed this morning?
Yes, can I have the next friend talk to me, please? Because I'm dealing with some issues. My mother just died.
Mr. Moore, my condolences to you. But this court is not allowed to have a non-attorney represent your interest in this matter.
I'm also his power of attorney.
I understand that, ma'am, but you are not authorized to represent someone else's interest in a legal proceeding. Power of attorney does not give you that right, does not convey that status on you.
Actually, it allows me to speak in on his behalf, according to several attorneys we spoke with that wouldn't take the case. Excuse me. And all I'm asking is if you could give us a couple of hours and put us towards the end of the docket so we can try to get you some things. There are a couple of things going on other than just the funeral. That's why I try to get an extension, even if it's for a few days.
Respectfully, ma'am, this is the end of the docket. This court's next case is not scheduled until 1 p.m. The court did receive the request for an adjournment, and the issue is that this matter has been adjourned, as Mr. Brickner indicated, has been adjourned a few times already. And each time the court has been ready to call, the case, Mr. Moore is not ready. You've been in the lobby of, I believe, the clinic, out in the car, just not prepared to have the matter heard. So I understand life happens and people have other obligations, but when we're talking about an adjourned hearing, a hearing adjourned at your request or at the defendant's request, I expect the defendant to be prepared to proceed, and the court will not allow you to represent his interest in this matter. If the attorneys told you that the power of attorney were sufficient for you to represent another person, that is inaccurate. And if I allow you to speak on his behalf, Mr. Brickner will object. He indicated at the last hearing that it was the unauthorized practice of law. This court cannot condone, support, or encourage that activity. That being the case.
Yes, ma'am. Since we are all suffering from major grief, his mother was 92 years old and she just passed. And they're dealing with funeral arrangements that's supposed to happen on Thursday. Respectfully, he would like to.
I would like to ask you for adjournment for a couple of days if I can, please. Until I at least bury my mother.
They have the escrow.
Your Honor, the last time we were here, they said they needed an adjournment so he could hire an attorney. I'm sorry for the passing of his mother, but the fact of the matter is that this keeps getting stretched out. Escrow is due today, wasn't paid. There's currently a rent in the amount of $4,500, including late fees and court costs in the amount of $164. There's $1,300 in escrow. This is commercial. This is a storage facility, Your Honor. It's not a residential. We actually sent the court because they were complaining about either mice or rats, and my client did hire an exterminator. We sent in a copy of the bill to show that he has done that. The whole building is the residential portion is being inspected by the city, and there was a few things that had to be done, but it didn't deal with health. And but that's irrelevant because this is storage facility, and we're just asking for. They didn't deny that they are in possession of the premises of the storage facility, and they didn't deny that they owed rent. They're giving reasons why they shouldn't have to pay rent on what's considered to be commercial property. I'm asking that the court enter a judgment in the amount of $4,500 for rent and late fees, $164 in costs, and give them credit for $1,300 that was been paid in escrow and ask that that be released to the landlord.
Yeah.
Mr. Moore, have you heard Mr. Brickner indicate that there's $4,500 in rent due on this storage?
I object to that, Your Honor. We had an issue with the court, which I have the paper right here in my hand showing that we have money. It was just that it was a fraud case on the case that has the money in it. So they set the account.
Mr. Moore, my question to you is there $4,500 in rent and late
No,
fees due
ma'am.
for the storage of the property at issue?
No, ma'am.
Have you submitted? Go ahead, Mr. Brickner.
I mean, the simple question, if I might, Your Honor. Mr. Moore, did you sign a lease?
Yes, I
The
signed
storage
it.
facility on October the 15th, 2022?
Yeah, illegal lease, yes.
Did you?
Then Mr. Brickner, no, we're not going to do it that way. The court is prepared to swear in the witnesses and take the testimony this morning.
Okay. All right, Your Honor.
That being the case having been called, the parties' appearances having been noted, Mr. Brickner, do you have any opening statement in this matter?
Your Honor, I'll just repeat what I stated, that there's the rent, there was a lease dated October the 15th, 2022. It's a 1-year lease. The rental for the premises was $650 per month. When it's not paid on time, there's a $100 late fee. We're indicating that April, May, June, July, August, and September rents have not been paid. Obviously, then there's court costs. And that I will indicate to the court that the court did enter an escrow order, and so far, July's rent and August rent has been placed in escrow at $650. And this is it actually says that the court should have a copy of the lease because it was filed with the complaint, and the court will note it's a commercial real estate lease, and there are obviously differences between commercial and residential real estate. And it's our intention to show that that's how much rent is owed, that the Mr. Moore's still in possession of the property. He is using it for storage, and that the landlord's entitled to his rent.
Mr. Moore, do you have any opening statement?
Yes. Okay. First, we found out that it was an illegal lease. Once we signed this, we had no certificates of occupancy or anything to back up that we was there until we had all these issues with stuff. Which was the power and everything that was promised to us was not on. And we had to keep calling him to get power. And then he came out. We didn't have power for like 4 or 5 months. And then he came out and hooked the power back up because somebody unplugged the power.
That's not true.
It's not true. But then we had rats. I have it in text messages also. We had rats and flies and stuff. And then stolen items from out of our unit.
Anything else for your opening statement, Mr. Moore?
And then also that the female that you were talking to, Miss Wilson, does live there too. And she's the one.
Sir, you have the absolute right to call her as a witness when you're putting on your defense to this case. But for right now, the court's question is, are you done with your opening statement, sir?
Yes, ma'am.
Thank you. Mr. Brickner, your first witness.
I'll call Mr. Moore, Your Honor.
Mr. Moore, raise your right hand for me, please, sir. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may put your hand down, Mr. Brickner.
Mr. Moore, do you recall you received a copy of the complaint for this action, correct?
Yes.
We didn't, and you got a copy of the complaint, and it was attached to the complaint. Did you get a copy of the commercial real estate lease?
Yes.
Okay. And The court also, Your Honor, do you want me to go through and formally introduce the lease? It's a part of the court's record anyway.
Well, he's acknowledged receipt of it. It is in court file, sir, so it is part of the, it's already part of the proceedings.
The copy of the lease that you received is the same lease that you signed. Your signature's on the lease.
Oh Lord, he passed out. He passed out. He suffers from vertigo. He had a stroke. You say I can't speak for him, so I mean I don't know what to tell you, Your Honor. He's grieving real bad. I don't know what to tell you, Your Honor.
Well,
Ms.
Your
Wilson,
Honor,
here's the issue. Here's the issue from this court's perspective. And we had the conversation at the last hearing. The demand for possession in this matter was signed on May the 18th, 2023. At the end of that paper, it lists the right to have legal services. At the first hearing in this matter, hearing of this matter, my resolve would have gone over those rights as well. You have had now almost 3 months to call and, well, over 3 months to call and retain an attorney.
We have been calling.
Today is the day and time scheduled.
Favor the landlord and won't represent us. And Lakeshore Legal Aid, we talked to them this morning. They're sending an emergency email trying to get someone in to help us. But this is the day after the holiday. The day after the holiday, we're at the bank trying to get your money to put in an escrow. Giving this gentleman 1 more week is not going to hurt anyone. His money is sitting there in your account.
You are doing exactly what the court said you cannot do. You cannot represent his interests. And you showed Mr. Moore sitting on the floor. You showed Mr. Moore sitting on the floor. And here's the other issue. Mr. Moore knew that this case was scheduled this morning at 11 a.m. You should not have been anywhere other than a quiet area to conduct the hearing of this matter.
This is a quiet area, ma'am. This is a quiet area. I'm just asking for time for him to try to recover. He's sick and he's mentally. His 92-year-old mother died, ma'am. Just give him a couple days, please. Just a couple days. I'm the one who paid the bills, okay? Yeah, the escrow money I can have it because of the holiday. My check was late. I can have it in a day or two, please, ma'am. I'm begging you.
well, Your Honor, while he's recuperating, maybe I can just put testimony on from my client.
How do you put testimony on when a necessary party, the named defendant, is unavailable?
I don't know what to tell the court. Again, this is our fifth appearance on a landlord-tenant case on a commercial property.
I'm sorry, we can't do this here. I need you to come down. Okay, I'm sorry.
Take it slow. Take it slow. Please, I can't pick you up. Take it slow.
Ms. Wilson, where are you?
I'm at the bank trying to clear up a problem that I have so I can bring the money to you. I was hit with fraud and my account was frozen. So I was taking care of that to bring the money to the court today. Because per the contract I have today to get the money in. So I was trying to handle that for him because it's a lot that's hit this family right now. You know, and I'm just asking for a couple days to give Lakeshore Legal Aid a chance to come in.
Ma'am, where is Mr. Moore?
He's sitting outside. He's sitting outside, or he's trying to make it now to the car to sit down.
Ma'am, I'll say it for the third and the last time. Today is the day and time set for the hearing in this matter.
1 second,
Mr. Brickner is here. Mr. Brickner is here. His client is here. We adjourned this matter specifically to get to the bottom of the complaint and the answer that was filed. If Mr. Moore is unable to participate in these proceedings and absence himself from these proceedings, the court has no alternative other than to enter a ruling in favor of the plaintiff.
Hold on one second.
Uncontroverted.
Here. She says if you won't talk today, she's going to enter for him.
Hello. Hello?
Mr. Moore, are you in a position to answer Mr. Brickner's questions?
Not
He
really.
asked you about signing, you said not really?
Not really.
Mr. Brickner?
Your Honor, then if he's not, can't answer the questions, then I can have my client testify as to what is owed. And it'll be up to him to deny it. And I can cross-examine him at that point in time.
Mr. Moore, how did you intend to proceed this morning, sir?
I plan on asking for an adjournment so I can take care of the things I need to take care of with my mother.
Your Honor, when this thing started, it appeared that Mr. Moore was driving. Mrs. Wilson was in the passenger seat. He was in the driver's seat. I don't know what's going on here, Your Honor. I can proceed with my own client.
Mr. Moore,
Yes,
we will continue with this matter this morning. Mr. Brickner is correct. This matter was adjourned twice previously at your request. The court received a last-minute request for an adjournment of this case. And although I understand that you are bereaved, this is a case that's been pending in this court now for 3 months. So Mr. Brickner's question to you was regarding the lease that you signed last year.
Yes, ma'am.
You signed a
Mr.
lease?
Brickner.
I'm sorry. I didn't understand him. You admit to signing the lease, Mr. Moore?
Yes, ma'am. Yes, sir.
Okay, and this was for this particular lease was for storage facility, correct? Next to your apartment?
Yes.
Okay. And can you tell me how much the rent was per month?
I don't know how much it was.
Well, did the lease indicates that the amount of the rent for the full year was $7,800? You divide that by 12, is that $650 a month? Is that what your rent is for the storage facility?
I don't handle the bills. She handles the bills.
All right. Did you pay rent for the month of April?
I don't know. She handles the bills, sir.
Do you know if you paid month for April, May, June, July, August, or September?
I have no idea if she take care of the bills, sir.
Okay. Evidently, he's not in a position to answer the questions, Your Honor. If I just allow me to do cross-examination if he decides to testify, and I'll ask that and I'll go and get the information from my own client.
Thank you. Your client's name, sir?
Baha
Tell me your
Najm.
name. I'm sorry?
Baha Najm.
You want to spell
Would you
your
spell
name?
your name for me, sir?
Bahaa, last name Najm, Najem.
Thank
Mr.
you. Mr.
Najm,
Najjar, raise your right hand for me, sir. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. You may put your hand down.
okay. Mr. Najm, can you tell us what are you the owner of Ashaka Investment Properties?
Yes, sir.
Okay, and how long has Ashaka owned the property?
For a little bit over 2 years.
And it's been in your family for a while, is that correct?
Yeah, my uncle owned it before me.
Okay. And are you familiar with 21620 Sumter Road, the storage facility in the city of Belleville?
Yes, sir.
Okay, What type of a building is this?
It's mixed use building.
So do you have residential
Yeah, residential and commercial.
and you have storage?
Yes,
Okay. Have you had the building inspected recently?
yes,
And you're working with the city, you're working with the city to make sure everything's up to code, correct?
that is correct.
Have they done their final inspection yet?
No, not yet.
Okay, was the storage facility part of the inspection or just the residential?
Just the residential.
Okay. Did you enter into a lease with Mr. Moore in October of last year?
Yes, I did.
And can you tell me what the rental rate is?
$650 a month.
Do you have a late fee?
Yes, I do.
How much is the late fee?
$100 a month.
And do you know when the late fee kicks in?
Fifth day after the due date.
And how much is the late fee?
$100.
Did you get the rent for the month of April of 2022?
Yes, I did.
You got paid for April of 2022?
I'm sorry. No, I got last payment was March.
Okay, so have you been paid for April's rent of this year?
No, sir.
Have you been paid for May's rent of this year?
No, sir.
Have you been paid for June's rent of this year?
No, sir.
Have you been paid for July's rent of this year?
No, sir.
Have you been paid for August rent of this year?
No, sir.
Have you been paid for September's rent of this year?
No, sir.
So that's 1, 2, 3, 4, 5, 6, 7 months rent you haven't received, plus obviously they're late because you didn't get paid, correct?
Correct.
So the amount of rent and late fees is that $4,500?
That is correct.
And that'll pay you through the end of September this year.
That is correct.
Now, you've heard some complaints about power in the storage unit. Is there any power in the storage unit?
No. Basically, I had an extension cord from my the basement. We have power in the basement. I have extension cord. They have just 2 small lights that hook up to an extension cord, and we just provide those lights for them when it's dark.
Okay, is there windows or a door to the facility?
Yes, there is 2 double door.
So if they open the double doors, it lights the facility, correct?
Correct.
Is anybody living down? Is anybody living in that facility?
No.
It's strictly storage.
I'm sorry, sir. Did you say you object?
Yes, I do.
The basis of your objection, sir.
The objection is that when you open the doors, there's not enough light coming through the doors to see stuff.
Oh, Mr. Moore, that's not a legal objection. You will have the opportunity to ask Mr. Najjar questions and
Yes,
provide
ma'am.
testimony when you put on your defense. Thank you. Mr. Najjar, I'm sorry, Mr. Brickner, your next question, sir.
Okay. Have you been in the storage facility since Mr. Moore took possession?
Yes. Yes, I have.
Is Mr. Moore still in possession of the rent of the storage facility?
Yes, he is.
Is there any of your possessions in the storage facility?
No.
Is there stuff what's in the storage facility?
They have random stuff, like boxes and some toy stuff, toys for kids. And I would say it's almost empty. They have stuff that approximately is 20 to 30% full.
Have you been in and out of that storage facility during the time that they've rented when Mr. Moore rented it? It's not them, it's him.
Recently,
have you
yes.
seen any? Is the same amount of their personal items still there that have always been there?
Some of it, yeah. Some of it got removed, and they probably added a few more things. You know, from what I can see, I don't really pay a whole lot of attention when I go in on their stuff.
Okay, and the storage facility has lights, and how are the lights hooked into a power source outside of the facility?
The lights that I added, or you mean the storage itself came with lights?
Does the storage itself have lights in it?
No, it does not.
Okay, so how does the place get lit up?
Well, we have the extension cord from the basement to turn on 2 lights for them. That's what they requested. They said that was good enough for them.
Okay, so you're paying for the electricity though, right?
Correct.
They don't pay. He doesn't pay for electricity.
No, he does not.
Okay. And have you done anything about? There's been some complaints about rodents. Have you done anything about that?
Yes. Well, the first time that they complained, I had those gluing stuff that you put, you put peanut butter on them, and we caught, I believe, 2, and then they kept on complaining. So I hired a professional pet control to come and put everything in there.
Do you have? It's not just in that facility; it's all over the building, correct?
No, it's only in this facility.
Oh, okay, okay. And
yeah.
And Your Honor, we submitted. I don't know if the court got it. We submitted an invoice from the pest control company. Do you know how much you paid the pest control company to?
$200.
Okay, and that was in August?
Correct, yes.
Okay. I don't know if it makes a difference to the court, but if we had sent in a copy of the honey pest control bill. I don't know if the court has that.
The court did receive it. Did you send a copy to Mr. Moore?
Mr. Moore was there when the pet control people were there. We had to have access to the place.
So we're not charging Mr. Moore for the pest control, Your Honor. Just doing it to show you that it was done.
Mr. Brickner, the question was, did you show him? You want the court to consider it. So the question was, did you show Mr. Moore the receipt? Or are you just bringing it up to indicate that pest control?
Hold on a second, Your Honor. I'm
going
going to mute you. Hold on a second, Your Honor. I'm sorry, Your Honor. We just received it late last week. I was out of town. And it was submitted to the court so that the court would have a copy of it. Obviously, it's Zoom is Zoom, so we were happy to get it to the court. The only reason I bring this up, Your Honor, is to show that, in fact, Mr. Mike Baha has actually done something about the complaint about pests in that particular area. That's the only reason I raised the issue.
Understood.
So,
resume questioning.
All right. Okay. Well, so, Baha, you heard the complaint and you about rodents, and you did something about it. You didn't ignore it.
No, not at all. That was with the pet control. It was our 3rd time going in there. 2 times we tried to do it with the glue packs, and we caught 2 of them, I believe. And even though we had like 4 or 5 of them in the storage, it was one spot that we caught 2 at the same spot.
Have you caught it since the pest control's been there? Is there any other indication that there might be rodents in there?
No, sir.
Okay,
Not that I heard anyone complain.
Okay, but as far as you know, Mr. Moore you didn't remove anything from Mr. Moore's storage facility, correct?
No, I have not.
You didn't have any of your workers do anything of that nature?
No, they have not took anything out of there.
Okay, so
they had to run a camera wire and they had left the door that is connected to the other place. They had left the door open,
But that's
and
not
my
it.
guy.
That's not didn't give access to Mr. Moore's storage facility, correct?
What was your question again?
Okay. You said you ran camera wire. Was that for
Yes.
security purposes?
Correct.
Okay. Now, at running the camera wire, you indicated that you left the door open. That wasn't in Mr. Moore's facility. It was on the other side, correct?
Well, there is a door between Mr. Moore and the other facility. Mr. Moore had left that door open. So when I sent my camera guy, did not know that was someone else's place. And they just went and ran the wire, and that's all they've done.
Okay, but that you didn't open the door to the outside, correct?
No,
Okay.
no, we did not.
Okay. So you've never removed anything from the storage facility?
No, not at all.
Okay. And your basic contention is that, well, Your Honor, do you want me to actually formally ask the court to accept the lease as evidence for like Exhibit 1, or you're just going to accept it as is?
Formally move for its admission, sir.
Okay. I move that they have the lease admitted for admission as the lease between
Any
the parties.
objection, Mr. Moore?
Yes, I object because it's an illegal
You
lease.
object?
Yes, I
You
object.
object to the lease?
Yes, I do.
Well,
What, your objection is that it's an illegal lease? Is that what you said, Mr. Moore?
Yes, ma'am.
That's not a valid objection to the court receiving a document. The court will receive it.
As far as the pest control thing, Your Honor, I don't know that I really have to admit that to the court, especially since Mr. Moore didn't get a copy of it. It was just to show the court that he hasn't ignored Mr. Moore. He's actually doing something. I have no further questions for Baha.
Thank you. Mr. Moore, do you have any questions for Mr. Najjar? Not your testimony, but any questions regarding his testimony?
Can I recall the witness later, Your Honor?
You may,
Hello?
sir.
Okay,
You may.
Okay, I would
Thank
like
you.
to call him later. Now I want to call Dr. Wilson.
No,
to
sir.
the stand.
It's not yet, Mr. Moore.
No, not my turn? Okay,
Not your turn yet.
all right.
Mr. Brickner, do you have any other witnesses?
Well, is Mr. Moore capable of answering questions now? Is he sitting down?
It appears so.
Then can I resume examination of Mr. Moore, Your Honor?
Mr. Moore, are you prepared to be recalled?
Yes, ma'am.
Thank you. You remain under oath, sir. Mr. Brickner, you may resume your examination.
All right. Mr. Moore, do you admit to having signed the lease that was been admitted to the court?
Signing illegal lease, yes.
Never mind, Your Honor. You signed, that's your signature on the bottom of the lease, correct?
Yes.
And do you admit that when you entered into the lease, the rent was supposed to be $650 a month?
I don't know how much the rent was. I told you that. I don't pay the rent.
Okay, so do you admit that the lease states that the rental space is $7,800 for the year?
No, I don't know anything about that.
Do you have a copy of the lease with you?
No, I do not.
Did you get a copy of the lease?
Yes.
You admit there's rent, you admit that you're renting the place, the storage facility, correct?
Yes.
Okay, and and do you admit that you have your possessions, stuff that belongs to you in the storage facility, or anybody else is living with you?
It's there, but I do not handle the bills. He take care of the bills.
That wasn't the question I asked you. Do you have access to the storage facility?
Yes.
Do you have a key?
Yes.
Do you have possessions in the storage facility?
Yes.
Do other people have access to that live with you have access to the storage facility?
Just Shaka.
Okay, does Shaka have, if you know, does Shaka have property inside the storage facility?
Yes.
Okay, so you're literally in possession of the storage facility, correct?
Yes.
And you still have possessions in the storage facility?
Yes.
And I think you testified before that you don't know if your rent has been paid or not paid because you don't pay the rent, correct?
Yes.
So it very well might not have been paid, correct? You don't know.
I have no idea.
You have no idea. Okay, but you do remember signing a lease. Yes. You don't know what the rent is.
No, I do not.
And you don't know when the rent was paid through.
No, I do not.
I have no further questions, Your Honor.
Thank you.
I have
Mr.
no
Ricker,
further
do you have
witnesses,
any
Your
other
Honor.
witnesses? Thank you.
No, Your Honor.
Mr. Moore. The plaintiff has concluded its case. Sir, do you have witnesses to present?
Yes.
Your witness, please, sir.
Shaka Wilson.
Ms. Wilson. Please state your first and last name and spell them both for the record.
Shaka Wilson.
Spell your first and last name, please.
Shaka. Wilson, Wilson.
Raise your right hand for me, please. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Moore, your question.
Yes, ma'am. Yeah. Isn't it true that you take care of all the bills at our apartment?
Yes.
Is it also true that I have nothing to do with the financial part of our building?
Yes.
It's also that Shaka and them entered into the apartment without our storage, without our consent.
Yes.
Your Honor, I think I do it too, but it's all leading questions. Can you ask questions that she might be able to answer other than yes? I know this is difficult.
Mr. Moore, the objection is that your questions are leading.
My
So if you're
questions are
able to, leading, suggestive of the answer.
suggestion of it. Okay. So, all right. Yes, Your Honor. So, yeah. So, can we get a recusal of this?
A recusal?
Yes.
I'm not sure what you're asking, Mr. Moore.
Just a second.
I guess my basic objection, Your Honor, is he couldn't answer the questions himself, but he's asking yes or no questions now. So if he wants to ask,
He's asking for you to recuse yourself for judicial bias under MCR 2003, and we would like a higher judge to adjudicate this. That's what he's asking.
I'm sorry, ma'am. Hold on one second. I'm sorry, Mr. Moore, you're asking for this case to be reassigned?
Yes, ma'am.
On what basis, sir?
On the basis that it's more, to me, it seems like it's more favoritism for them than it should be, ma'am.
I'm sorry?
On the basis that it seems like there's more favoritism for them than it should be, ma'am. And I'm sick right now too, so I would like a higher judge to look this over.
that would, Your Honor, I'm going to object. That would be in the form of appeal after the court has made a decision, and the court hasn't made a decision yet. As far as recusing, Your Honor, I have no objections to the court continuing. It's obviously I've been doing this a little bit longer than Mr. Moore has, but this is, I'm sorry, Your Honor. I disagree with Mr. Moore's statement. I would ask the court to proceed.
Mr. Moore, anything else on your request for this court to recuse itself?
No.
Thank you. Mr. Moore, the court having not made a ruling one way or another because proofs remain open, I'm not sure where the conclusion comes that the court has some bias against you or the position that you're taking. And if you would like to detail what you believe that bias is, the court will, of course, hear it, but I'm not sure what has transpired in this case that you think that there has been some bias.
Because I need somebody else to do this because I can't stand up and talk really for myself. I need to find someone to do it or let her stand in and talk for it because she also did the apartment. And it's also part of the storage unit also. It's her on the case as well as our children.
Mr. Moore, I understand that and have allowed some latitude in terms of how you're presenting yourself today and how questions are being asked and answered.
Yes,
so it's not that I don't hear you. I'm trying to get us through this issue.
Yeah.
Are you prepared to resume your questioning of Ms. Wilson?
So you did. Okay, so excuse me a second. So you said that we should, instead of trying to get another judge, we should just go on with the case today?
Well, sir, you're asking that this case be reassigned because this court has shown some bias against you. And the question is, what do you believe that bias to be, considering that no ruling has been made on the proofs that have been presented so far, and that this court is continuing to take testimony?
Okay, but I'm disabled and I need her to stand in for me or someone to stand in for me and talk for me because I can't stand for a long time.
Mr. Moore, the issue is, and the conversation that was had at the last hearing is that this court cannot allow a non-attorney to represent you in this matter. It would be suborning the unauthorized practice of law, which this court is not allowed to do.
Mm-hmm. Yeah.
And that's why I say I understand that there are some issues and the court's allowing a little latitude in how you present the things that you want to present, but this court cannot allow anyone else to represent you other than an attorney licensed in the state of Michigan or authorized to practice law in the state of Michigan.
So, Your Honor, okay, I understand what you're saying. So, but can we have a 3-day recess so I can at least bury my mother and then we can continue this?
Mr. Brickner.
I'm kind of booked, Your Honor. I mean, I had a few things up to say. So my problem is this. Normally it's, and I understand this post-pandemic and everything takes longer than it should, but this is the 5th hearing on this matter, and they asked for a 2-week adjournment to get an attorney. They didn't get an attorney. And so far, he hasn't denied that he owes the rent. He admits he signed the lease. He admits he's in possession of the premises. He doesn't know how much the rent is, and he doesn't know if it's been paid or not. So far, he really hasn't done much to go against sort of the testimony that he signed the lease, what the rent was, and that he hasn't paid it since April. I don't know what adjourning this is going to do, other than prolong the whole proceeding again. And I mean, I'm not going to make any other comments. The court's been, like, you've been on the bench for a long time. You've heard a lot of different stories. And I've been.
This is not a story. I wouldn't play with my mother. So it's not a story.
Mr. Moore, here's the issue, Mr. Brickner. This court has concerns. When I first walked through here, Ms. Wilson was on the screen. They were moving through some space. When the court is prepared to call the case, they appear to be sitting at a table. And then Mr. Moore was on the ground, and he has now moved to a different location, which their outside is 85 degrees by what this court is able to see. Mr. Moore or Ms. Wilson, I'm not sure who, reached out to this court civil department last week and indicated that there had been a death in the family, but because of the history of adjournments, I wanted the parties to come on this morning. I, at this time, do not feel comfortable proceeding. Mr. Moore appears to have deteriorated over the last 45 minutes since we started taking testimony in this matter. I do not believe that we can proceed at this time. And over your objection, Mr. Brickner, I'd like to adjourn this matter. You having closed your proofs, the defendant just having started to ask questions of its witness. It is highly irregular, Mr. Moore, but it is clear that you are not prepared to participate in the proceeding this morning. That being the case, Mr. Brickner, respectfully, I'm looking at September the 20th.
20th?
In the afternoon. It's a Wednesday. It's this court's landlord-tenant date, September the 20th at maybe 1 p.m.
Your Honor, I'd ask that the escrow be continued, and if it's not paid today, because it was due today, that the case be, that a judgment enter.
I need a couple of days for this check to clear, Your Honor.
Mr. Moore, Mr. Brickner, are you available on the 20th at 1 p.m.?
Yes, Your Honor.
Mr. Moore, are you available on the 20th, September 20th at 1 p.m.?
Yes, ma'am.
Okay, Mr. Moore, just so we're clear and everyone's on the same page, on September 20th at 1 p.m., we will resume with the defendant's witness, plaintiffs having rest. You will deposit the escrow that's due for September by Friday, September the 8th, 2023 by 3 p.m. here at the 34th District Court. If that escrow payment is not posted by that date and time, there will not be an additional proceeding. When this court prepares to call the case on Wednesday, September the 20th at 1 p.m., you need to be somewhere where you are able to see and be seen, hear and be heard, and be ready to proceed. If you use these next 2 weeks to retain an attorney, they know how to make themselves known to this court by filing an appearance. We will be taking testimony. There will not be walking around, moving around. There will be testimony. If there's someone who supports you who needs to write out what it is that you'll be asking, you have 2 weeks now to get that done. But Mr. Brickner is accurate. These are called summary proceedings for a reason. They are supposed to be short and concise, and this is neither. That being the case, we now being on the same page, September the 20th, barring some catastrophe, will be the last hearing in this matter before judgment is entered. If there are documents that you want the court to consider, you must submit them to the court, copies to Mr. Brickner. There is not a screen sharing function in the Zoom meeting that will allow you to share documents on September the 20th. Mr. Brickner, anything else in this matter?
The only thing I would really like to point out to the court is this lease expires on the 14th of October.
I saw that this morning. Thank you, Mr. Brickner. Anything else, Mr. Moore?
No, ma'am.
Notice will be mailed to you, Ms. Wilson. I'm sure you've heard what the court just indicated on the record. I will see you on September the 20th at 1 p.m.
Thank you very much, Your Honor, for your time. I request the court to leave, your permission to leave the court.
Absolutely. Thank you, Mr. Najjar, Mr. Moore, Ms. Wilson.
Thank you, Your
You're
Honor.
free to go.
Thank you.
Thank you, Your Honor.
And this court will stand in recess. Next case is not scheduled until 1 p.m.